Yes, Mr. Williams.
Sir, ladies and gentlemen, my name is Lloyd Williams. Together with Mr. Christian Howells, Miss Laura Shepherd, and instructed by Watkins and Gunn, we represent 237 individual co-participants. We also represent Haemophilia Wales, Haemophilia Northern Ireland, Hepatitis B Positive Trust, and CJD Support Network. So it's almost 4.5 years ago that I stood up and made our opening remarks. One point I made at that time was how difficult it was to make submissions without hearing any witnesses, not receiving any statements, or being served without any documents. I rather regret saying that at the time, having received hundreds of statements, tens of thousands of documents. Fortunately, we've had the benefit of Miss Richards and her team, who've guided us through the material as it's emerged. My clients would like to thank Miss Richards, as I think most of them did when they'd finished their evidence. On the morning I made the opening remarks, I was approached by one of our co-participants. She was upset. She told me, as she subsequently told you, sir, in Cardiff, that she'd been infected with hepatitis C when she received blood transfusion on the birth of her child. She was unaware that she'd received a blood transfusion, and it was some time later that she became aware of the transfusion and that she'd contracted hepatitis C. Prior to the birth, she was a regular attendee at a blood transfusion centre. Once she'd recovered from the childbirth, she recommenced providing blood. When she was eventually warned that she was infected, she was told she couldn't give blood anymore. She was very upset. She'd been giving blood in the previous years, and she'd given blood in the period between the birth of her child and the time when she was eventually warned, sometime later, that she'd been infected. I mentioned this when I opened our position 4.5 years ago, and I produced her transfusion card. Well, sir, the world keeps on turning, and yesterday, Mrs. Elaine Huxley, who's here somewhere today, produced another document. This was from Velindre Cancer Hospital, confirming that she's got terminal cancer. The event confirms, if we need it, the terrible events that we're dealing with. The consequences are not what occurred, or not just what occurred 10, 15, 20 years ago. They're the here and now, and they'll go on into the future. It's very important to bear in mind, we say, and our core participants would say, that due regard is not just had for those who've suffered in the past, although that's very, very important, but that due regard is had to those who continue to suffer, who continue to be deprived of fathers, children, and who need care and assistance into the future. So we'd like to thank Mr. Stephen Snowden, KC, and his junior, Mr. Brian Cummings, for the heavy lifting on many of the issues that touch upon all our core participants. It makes our task that much easier. In respect of those submissions made by Mr. Snowden that you find persuasive, then we join in on those. Any of his submissions that you don't like, we don't join in. So these submissions will focus on the main issues with which our clients are concerned. Many of our clients have a particular interest in events in Northern Ireland and Wales, and I think Mr. Howells will be dealing that in the second half of these submissions. We don't intend to cover every topic. The inquiry has an extensive team and detailed knowledge of the evidence. As such, we will, for the most part, not rehearse evidence, save for references to key documents and excerpts of the oral evidence where necessary. This inquiry, it's been said many times, should have been held decades ago, when events were fresher, memories sharper, and more key witnesses would have been able to give evidence. Importantly, many infected and affected who are no longer with us would have been able to bear witness to this inquiry and the findings which it will make. No adequate explanation has been put forward by any of the ministers or civil servants as to why this inquiry was not held sooner. The line taken by government that patients received the best treatment available, given the medical knowledge at the time, became entrenched, notwithstanding that it was wrong. It was done so at the expense of an open-minded review of that position, until now. Before I look at the material that I want to consider, which will cover future compensation, future medical support, and past support, I have to say, I have the thunder taken out of some of my submissions in view of the ones you've heard just now. I'll do my best. I'd like to just look at and consider the opening remarks we made, because it sets out, if you like, a test against which this inquiry can be measured. We, in our opening remarks, identified 3 issues that our clients particularly wanted you to address. The first one was that they wanted their stories heard. For 30, 40 years, people have spoken on their behalf or not spoken on their behalf. This was the opportunity, and we urged you to allow them the opportunity to tell their own stories. Secondly, we raised the issue of they wanted the truth. They didn't want the whitewash. They wanted the truth from the witnesses. Whether we've had the truth remains to be seen. The third issue they wanted us to raise was justice. There's a number of elements to justice. I'll go through them in one moment. Going to, they want their stories heard. So one should not underestimate the sheer anger felt by the victims. Victims was the word we used at the time, and for the moment I'll stick with that word. Their feelings are as raw today as they've ever been. The victims feel it is important at this stage that the inquiry has given a flavour of how their lives have been destroyed. There are a number of themes to be considered, and we suggested at that time, sir, that these were the themes. The initial shock of infection, the ill health associated with infection, compounded by the ill health associated with any pre-existing condition, the various forms of treatment that are undergone, such as liver transplants, the combined effect of hepatitis C and HIV, to which we would now add HBV, the stigma attached to those conditions, ostracism from their friends and their local communities, the shock of finding out that their infection could have been avoided, the anger, resentment, and bitterness they feel towards those whom they trusted and were entitled to trust, the financial devastation that followed infection, the ruined family and private lives of the victims, the guilt that the victims feel about potential infection of their loved ones, and the burden they feel that they've brought to their families, and also a particular difficult cohort, the guilt of the wholly innocent parents feel for not questioning the treatment which was provided to their children, and in some cases to which they administered to their own children. This is not an inquiry simply looking into the past. It's an inquiry, as we said 4.5 years ago, looking into the here and now. Now 4.5 years later, I can say it's for the future from here. So the question arises about the material that they wanted to tell you about. And in respect of that, we referred to 2 letters which we read to you. I'm going to remind you of those letters that become relevant later on as well, but I'm going to remind you of the letters that I read to you. The first one said this: "From our experience, the UK government has been evasive, dishonest and cynical. The Department of Health has been hostile in its responses to campaigners and MPs who have debated the matter in Parliament. They have refused to both fully accept responsibility and to offer realistic compensation. They have engaged in political trickery and treated victims with contempt. The Department of Health clearly has a lot to hide and has been aggressive in defence of its own interests. The financial assistance given has been piecemeal and grudging. The use of contaminated blood and its consequences is a scandal, but the attitude of the Department of Health to victims is an even bigger scandal, provoking great anger, distress, and suffering, adding insult to injury." The second letter is this: "All widows have been given a life sentence, some a double life sentence if they've been infected as well, for a crime we did not commit, and we suffer daily from something we did not do. We have been there when our husbands have discovered that they've become HIV positive and or hepatitis C positive. We've watched our loved ones become ill. We have often given up our jobs and careers to nurse and care for them, enduring hardships in consequence. We've had to endure the stigma of those illnesses with them. We've suffered harassment and prejudice. We have often been too frightened to tell our families about the truth of loved ones, perhaps lying or keeping secrets. We've had to tell our children, if we've been able to have them, that their father was ill and dying while others have been denied the chance of ever having children. We have watched our loved ones slip away, hold their hands as they do, and see them die horrific deaths. Bury them and afterwards try to rebuild our lives with a constant background of this travesty in our minds and with little support. Many have been unable to work again. They've been traumatized, had breakdowns, been left to become single parents and bring up children who've been left without fathers. A few widows have become homeless and some have committed suicide. Well, they wanted to be heard. They wanted to tell their stories. Have they been allowed to? This is primarily directed towards you, sir, because you're the one who's had control of this inquiry. Overall, the feeling is, yes, you've allowed them to be heard. You've allowed them to have their say without constraints. They were allowed to say, within limits, whatever they wanted to say. And they were allowed to do it in their words, and they were allowed to do it in their way. So, unusually, we had straightforward hearsay evidence. Some people were referring what had happened to their father, even though they themselves were not alive at the time, they hadn't been born. They appreciate, sir, they fully appreciate that you're not just going to take their evidence as it is, that you'll be weighing up other evidence. You won't deal with individual cases, individual allegations. You'll look at the matters in the round. They accept that. But they've finally been able to speak on behalf of themselves, and for that, they thank you, sir. The second issue which we looked at was the truth. The way I put it then, 4.5 years ago, is they want the truth. When do they want it? 30 years ago. Well, we can say 34 years ago they'd like the truth. they would have liked the truth. The victims are angry that the government has not faced up to what happened and hasn't accepted responsibility. During those years, they fought tooth and nail for everything, including treatment and financial support. This is the first, and undoubtedly the last opportunity, for the victims to know the truth about why, for what reasons, and in what circumstances they are exposed to contaminated blood products. It is of the utmost importance, and they know that it is your intention, sir, to get to the truth of what had happened. What do they want the truth about? We asked ourselves 4.5 years ago. In one sense, the answer to the question is quite simple and straightforward. They want to know the truth about everything concerning the desperate situation in which they have been placed by the actions of others. Taking a slightly more focused approach, they wanted the truth about each and every item identified in the terms of reference. Whether they get the truth is up to you, sir. We know you will consider the evidence very carefully. You've been assisted throughout by Miss Richards, and we're satisfied, those we represent are satisfied, that you're, if I can put it this way, you'll do your best, and we're sure the best will be very thorough indeed. So the last thing we wanted is perhaps the most difficult one. We wanted justice. It's difficult to know how you can measure justice. In this case, thousands of people have died, thousands of people still suffer from very severe ill health, and tragically, as we just heard, it is likely that in the future, more will discover that they've been infected with hepatitis C, and more people will fall very ill. The victims regard this inquiry as a search for justice. There's a general view amongst the victims that for over 40 years, people in the know have kept their mouths shut, their files closed, and their shredders busy. All they've received for all the suffering was a belated apology from Prime Minister Cameron in 2015, for what that's worth. Updating things 4.5 years later, we have an apology on behalf of the Department of Health, which echoed an apology given a couple of days after I made our original submission. It was at that time an unreserved apology for what had happened. Quite where we stand on that apology, I don't know. And at the moment, neither do you, sir, since they declined to expand upon what they were admitting, which is an extraordinary position to take. Whether or not they were entitled to refuse to answer your questions is a different matter, but it was contemptuous. Not Miss Gray, of course. I don't blame her at all. What it was that Mr. Snowden said the previous day, which prompted them to halve their final submissions, is difficult to know. Mr. Snowden was very persuasive, and the 6 points he raised were, we thought, and respectfully endorsed, were hardly a surprise to the Department of Health. They should have foreseen that coming. So the question of justice includes, we would say, and this is a matter I'm going to deal with in more detail, provision of health services. I'll just leave that where it is at the moment, because I'll be coming back to it. And also compensation. I'd just like to look in a little more detail as to what compensation is. There's a danger that people, general public, might misinterpret what compensation is all about. In fact, the press often misinterprets what compensation is all about. It's made to seem, in some people's eyes, as a win on the lottery. So people are awarded 50,000, 70,000, £1 million, £5 million. It's seen as a win on the lottery. They put their hand in the brand tub, and they brought out a cheque for £250,000. You will know, sir, that's not the case. I would like to take you to the report of Sir Robert. It's page 41 of his report. He very helpfully identifies the rationale for compensation. Page 41. Terms of reference. To consider the rationale for compensation as a matter of general principle and in relation to any particular classes of compensation, recognizing that it is not for the study to preempt the determination of the infected blood inquiry as to what, if any, rationale is supported by the evidence that it has received. Definition of compensation. What does the term compensation mean? When participants in our meetings were asked, few were able to describe clearly what their concept of compensation was. Therefore, it may be helpful to set out the way in which it is intended to use the term in this report. To start with, for the common use of the word, we can refer to an online dictionary definition: something, typically money, awarded to someone in recognition of loss, suffering, or injury. Other dictionary definitions include money that is paid to someone in exchange for something that has been lost or damaged or for some problem. Something that makes you feel better when you've suffered something bad. The act or process of making amends for something. A number of features should be noted. Compensation. It is not limited to an award of money. It involves a process. It recognizes that a person has suffered from an injury or loss. It is intended to redress that injury or loss. Then, jumping over the next paragraph, we're going to paragraph 4.6. The purpose of this study, I shall adopt the following definition: an award of money or some other remedy to persons who have suffered injury or loss indirectly or from infected blood or blood products found to be eligible for such an award, to provide them with redress for and recognition of the adverse experience they've suffered. It's compensation for an injury. If the injury is small, compensation will be small. If the injury is awful, long-lasting, or causes death, the damages, the compensation was commensurately higher. So, once again, there is a tendency amongst the public and the press to regard people who seek compensation as somehow a form of ambulance chasing, that people just want the money. No doubt that will be raised in this case, if it hasn't been raised at all so far. The way we put it is like this, simple and straightforward. What would you rather have? Your son alive or a large sum of money? You look at it like that, it's very straightforward. Compensation is there to compensate people for an injury, and in these cases, very, very serious injuries. I just want to compare some people's understanding of what compensation is about and why it's awarded, that it's linked to fault, with some former ministers' appreciation of what compensation is about. And I'd like now to be played a film of Edwina Currie.
Just a year after Mrs Curry's famous salmonella in eggs outburst, which lost her her job as Junior Health Minister, she's back in the thick of things again. Today, in a letter to a national newspaper, she entered the AIDS debate and angered hundreds of sufferers and health experts in the process. Her comments were aimed at around 600 haemophiliacs who were taking the government to court, claiming they contracted the AIDS virus from infected blood brought in from America. They say health authorities should have done more to ensure the blood was safe. In the letter, Mrs Curry criticised their campaign, saying, "We appear to be on the verge of claiming that people should get very large sums from the state just because they're sick." She says haemophiliacs with the AIDS virus are no different from any other sick person and have no automatic right to compensation. What about asthmatics and epileptics, she asks. Why not pay £50,000 to every blind person or those with multiple sclerosis? Haemophiliacs who contracted the AIDS virus from infected blood are outraged by the statements. They say it's impossible to compare their plight with other illnesses because theirs could have been prevented.
I'm quite staggered to think that anybody, let alone Mrs Curry, could show such apparent lack of understanding for the plight of people who have got both haemophilia and HIV infection. I know Mrs Curry is well known for making outrageous statements, some of which are farther from the truth than others, but I think this time she really has gone over the top.
If Mrs Curry is unsympathetic to haemophiliacs infected by the AIDS virus, then it's an about turn on her comments in her recent biography. In one chapter, she recalls how upset she was when an infected haemophiliac came to see her at her office. "The full horror of the situation suddenly struck me," she wrote. "I asked if there's anything I could do. The woman told Mrs Curry she'd done enough by just listening and ended by saying, 'It's important that people like you understand.' Tonight, Mrs Curry was unrepentant, insisting there were far more deserving cases for compensation than haemophiliacs suffering from the AIDS virus.
I'm always very concerned about the underdog, the person for whom there isn't a campaign, the person who is not hitting the headlines, the person perhaps who it is our job to look after. And sometimes their need is just as great as the emotional campaign, and occasionally it's much greater."
Despite Mrs Curry's comments, the haemophiliacs say they'll continue their legal action against the government. Next year could see nearly 1,000 of them in a High Court battle for compensation.
That film was made just a couple of years after Edwina Curry had to stand down from being a junior minister in the Department of Health. Her comments were crass, unbelievably stupid. She was supposed to know about the disaster that was then unfolding. She was supposed to know about how HIV was at least said to be caused by the government. She equated HIV and, by extension, hepatitis C to something that just happens. They didn't just happen. They happened because of the faults of the government. She failed to recognize that. In the position that she'd formerly held, she would have known about the disputes that were taking place. If she doesn't know the difference between compensation and just doling out money, if she doesn't know the difference between having suffered harm, someone gets compensation, and someone who hasn't suffered harm, then how can we blame members of the public, and perhaps even we can let out the press for not knowing the difference? Her attitude there was appalling. We'll come back to Edwina Curry later. I see by the time we're getting up to 11:15. I don't know whether you want to stop or just go on. I'm quite happy to go on.
If you're happy to go on, then go on, and we'll take a break about 11:30
Yes, sir.
if that would suit.
That was all an introduction to my first point upon which I'm going to address you, which is compensation for the infected and affected. What should be done? Our proposals for the scheme of compensation, its structure, and the issue of eligibility and the calculation of quantum are based primarily on the evidence of the infected and affected. It's also based on the recommendations and all evidence of Sir Robert Francis, King's Counsel, the evidence the inquiry has received concerning the means and systems providing compensation and support in other countries, particularly the Republic of Ireland, the present systems used in the 4 countries for the support of the infected and affected, and the existing common law systems operated in the 4 countries in the UK. The role of compensation is of the utmost importance. It represents a clear, unambiguous acknowledgement of the acceptance of responsibility for this disaster, including HCV, HIV, HBV, and UCJD, an acceptance by the UK and devolved governments. The mealy-mouthed words previously used by them to justify the minimum amounts of money they provided can be put behind us, we hope. And we hope that responsibility is accepted. Further, the payment of compensation should be seen as an acknowledgement by them of a continuing obligation to provide appropriate, fair, and reasonable compensation and support in the future. The 4 existing schemes for the provision of financial support for these infected and affected should be amalgamated into one new system for compensation and support. Until the new system is set up, we accept it will take a little time, until the new system is up and running, the amounts paid to the infected and affected will be given parity between the 4 countries, so that under the respective headings of loss, each claimant receives the same amount. The government should establish a single scheme by which each of these infected and affected receive fair, just, and equitable compensation for the harm they've suffered, and in most cases will continue to suffer for many years into the future. The compensation paid should be the same wherever the recipient lives. In order to meet these requirements, the system should be founded on the following principles. First, the infected and affected should have an official, unambiguous apology from the UK government for the harm caused to the infected and affected, and an open acceptance by the UK government that the need for compensation arises because of their responsibility for the harm they caused to the infected and affected. Secondly, the compensation is paid as of right, not as a matter of charity, but as of right because of the harm they've suffered. We adopt those principles set out in Sir Robert's report at paragraph 4.75. I'm going to go through those, and that will take a little time, so now might be time to stop it.
Very well. Well, we'll stop now, and we'll come back then at 10 to 12. So 10 to 12. Yes.
So we were going to look at the principles as enunciated by Sir Robert, and that's at internal page 60 of Sir Robert's report. And just to explain the context of this, I was just going to the principles upon which the system that we propose, so our system, and setting out those principles. And the first one we adopted was that set out at paragraph 4.75 of Sir Robert's. So we're going to have a look at that. Principles. Having considered the rationales proposed for compensation as opposed to support, I turn to consider the principles which should underpin a compensation scheme. And then next down, remedial. The aim of a compensation scheme is, so far as can be achieved by provision of money, support and services, to provide eligible persons who've suffered injury or loss directly or indirectly from infected blood or blood, with proportionate redress for and recognition of the adverse experience they've suffered. Respect for dignity. The scheme must restore and preserve applicants' dignity and treat them with respect and confidentiality. Collaborative. The scheme should be collaborative with and supportive of applicants, and so far as possible avoid an adversarial approach to claims. Applicants should be believed unless the contrary is proved. Choice. The scheme should respect and enhance the autonomy of applicants, including offer a choice of how remedies are delivered. Individualised. Awards should reflect in a proportionate and consistent manner the individual circumstances and experience of applicants. Inclusive. The scheme should recognise the direct impact of the infection and its consequences on the infected person, but also the indirect impact of the infection on those close to the infected person. Non-technical. There should be no bar to eligibility based on technical issues such as limitation through the passage of time since the onset of the infection and its consequences. Accessible. The scheme must be as readily accessible, understandable, and free of complexity and stress to all potentially eligible persons as is reasonably possible with appropriate assistance. Just underline that last two words, appropriate assistance. So that's a matter which we'll look at in more detail in one moment. Then goes on, ease of proof. Unjust, distressing and disproportionate requirements of proof and evidence should be avoided. Broad, measures of compensation should be designed so far as is possible so that they are easy to apply and represent broadly fair, proportionate compensation for the injury and loss suffered as a result of the infection, with due consideration of, but without being bound by, the boundaries of entitlement to damages in law. Improving. No claimant for compensation should be worse off than they would be entitled without such a scheme, and an award of compensation should not prevent the pursuit of any entitlement to bring legal proceedings for the same subject matter. Then over the page, top of the page, complementary. The continuing payments under the existing schemes, support schemes, should be continued and made more secure regardless of any claim for or award of compensation. I just want to stop there, so it's not always easy for people unfamiliar with litigation or inquiries or compensation not to necessarily follow what we're saying. Lawyers talk one language, general public speak their language, and they don't always cross over very well. So I know this is a matter of great concern to many of our core participants, that they fear that if they have an award of compensation, they will lose the regular payments they're receiving at the moment. And it's crucial to many people that the regular payments they receive at the moment continues into the future. And it's clear from Sir Robert's principles there that he agrees with our clients. So, sir, that's a particularly important matter. They don't want to forego regular payments for compensation. They want both. Then continuing, holistic. Compensation is not just about money, but should also include consideration of material means to compensate for what has been lost. We can take that down. So that's Sir Robert's recommendations. We've drawn up our own list of recommendations. To an extent, it mirrors what Sir Robert has said, or maybe a slightly different way than Sir Robert has said. But we thought it appropriate to set out certain additions. So, firstly, the purpose of the scheme is to ensure that everyone who is entitled to compensation receives compensation. The scheme, we say, should be judge-led. The scheme must be wholly independent of government, whether UK-wide or devolved. We say there must be a dynamic, vigorous and proactive approach to identify those entitled to compensation. There should be a search for them, and all possible methods must be used. Although there may, in some claims, be disagreement concerning the entitlement of compensation or the amount of compensation, the process of making a claim and resolving the amount of compensation must, so far as possible, be dealt with in a non-adversarial way. The purpose of the process is one where the infected and affected are to receive the appropriate amount of compensation, not one where pressure is applied, direct or indirect, or to accept less than the claim is worth. A person seeking compensation should not be required to waive their rights to pursue litigation. The issues as to whom should receive compensation and the amount that should be paid should be resolved as soon as is reasonably practicable. However, this has to be balanced against the understandable desire of the infected and affected to have careful consideration given to their own individual case. So if I can just stop there for one moment. The tension between those two things can be met to an extent, of course, by another interim payment to those who've received an interim payment already, and in respect of those who have not received an interim payment, to have an interim payment in the very near future. That would allow some recompense, some compensation to those who need it, and they all need this money, but also allow a balanced view to be taken about the scheme to be set up and how the compensation is to be calculated. I continue. Those recruited to run the scheme must be provided with appropriate training in all aspects of their respective roles. Contrary to the position by Sir Robert, those who we represent would wish to have the opportunity to be legally represented going through this process, paid for by the UK government, so that the core participants, or those seeking an award, can receive appropriate advice and reassurance regarding the process of seeking an award of compensation, advice regarding the various types of compensation, and support and full explanation of any decision they may have to make in respect of eligibility and quantum. It would be wholly inappropriate for the infected and affected to have to rely on the guidance and support of employees of an institution which is financed by the body paying their compensation. There's an obvious room for conflict of interest, we say. So people don't have to have a lawyer, but if they want one to help them, to give them advice, particularly on the compensation to be calculated, the quantum of it, then it may well assist them if they have a lawyer. Given their previous experience of the trusts and schemes where they were treated with disdain, contempt and distrust, dealt with as beggars seeking charity, not as a person who had a right to compensation, and where those who were acquiescent in this regime might be treated more generously than those who tried to stand up for their rights. Waiting for a relationship of trust to develop between the infected and affected and those seeking to administer the scheme will take a long time. In order to make sure that the process of assessing the amount of compensation to be awarded proceeds as smoothly and quickly as possible, the UK government should finance the provision of legal aid and representation of the applicant. We say there are further advantages in having legal representation. Firstly, the application for compensation will necessarily require detailed consideration of the applicant's medical records, which sometimes will extend to a number of lever arch files. This is likely to be a traumatic and upsetting process for the claimant, as they are reminded of the many painful events which have occurred and which in many cases will continue into the future. This may be less traumatic if they are able to rely on legal representatives who already know the background to the scheme and the issues that may need to be explored in any individual case. Secondly, their medical records are likely to contain private and confidential information unrelated to becoming infected, which should not be shared with strangers. 3, their present solicitors will have access to the medical records, and they will know the issues likely to arise, and so will therefore be able to start processing their application for compensation immediately. Those who don't wish to be instructed by their present solicitors, then of course they're at liberty to instruct another solicitor. Insofar as may be necessary, the UK government shall fund the instruction of such independent medical experts as the person claiming compensation may reasonably require. Those who receive compensation shall be entitled to an annual sum to pay a financial advisor to help them invest the compensation and to manage their financial affairs. The new scheme shall be funded by the UK government. The amount of money required to fund the scheme shall be provided by the UK government on an annual basis. There will be no more reserves maintained by the body administering the scheme. The new scheme will be capable of being accessed locally to ensure that, so far as possible, a trusting relationship eventually develops over time between those administering the scheme and those receiving compensation. The scheme should be co-designed by a committee which should include representatives of the infected and affected so as to ensure that appropriate weight is given to their interests and concerns. There should be a representative of those infected and affected on any group, subcommittee or panel involved in setting up the scheme or continuing to run it thereafter. The infected and affected should be invited to play an active and collaborative approach in the continuing development of the scheme. Every effort should be made to ensure that the infected and affected are not cut adrift or simply drift away from the tribunal or the scheme. The framework of the scheme. There should be established a judicial body known as, this is our suggestion, sir, the Infected Blood Tribunal. The lower level should make initial decisions on eligibility and quantum. The adjudicators should be of such caliber as to engender in those making an application confidence and trust in their independence and ability. Those making decisions affecting eligibility and quantum should be experienced in the assessment of damages for personal injury claims and the assessment of relevant medical matters. They should receive training in the possible effects of the relevant diseases. They should be provided with information concerning why this disaster occurred and the devastating effect it has had and continues to have on individuals and families. They should be told of the way the infected and affected have had to fight for justice for many decades against intransigent, uncaring and defensive governments. The rules and procedures should be clear, straightforward and well publicised. Each tribunal of first instance shall be presided over by a circuit judge.
Why do you say that?
Because
go ahead.
For this reason. First of all, the amount of money that will be considered by the judge will be considerable, in some cases very large sums of money. The claimants must have confidence in the person they appear before, that they know what they're dealing with.
Well, that was why I asked, actually. You're proposing a tribunal. There is, in HMCTS, the key is the T, a parity, as it were, between courts and tribunals. Tribunals have the advantage, it may be said, of being less formal in their procedure, of tending to be quick, and to have rules of procedure which are rather simpler than the rules of civil procedure, which, as you know, are quite complex and complicated. It also involves people who are dedicated to doing the particular task that they do, whereas circuit judges are either, and generally, dealing with crime in most of their career, or to some extent, in some cases, dealing with civil. There isn't an awful lot of civil litigation currently conducted, I think, in the county courts. So it might be, I'm just asking really for your reaction to this, if the proposal is that there be a tribunal with an appeal tribunal beyond, why shouldn't it be a tribunal judge within the tribunal service having the support of the senior president of tribunals ultimately, who, as you know, is on a part of the, or almost on a part of the Lord Chief Justice?
Well, so there are a number of reasons. First of all, from a practical point of view, as the scheme develops over the years, there'll be less and less hearings. There'll be less and less call on circuit judges. So whilst they may be kept very busy and be on their feet, in the initial few years, eventually the amount of work will diminish. So the needs of the schemes can be, we say, met by the existing circuit judges. We also say that this is a very important tribunal. It will be seen as such as very important. It's very important that the court participants have confidence in the people they appear before. Circuit judges, their status is well known. District judges sound somewhat less important than a circuit judge. It's a matter of appearance, it's a matter of regular knowledge and working with large personal injury claims. The position seems to be at the moment, that even though district judges do have ability to deal with compensation.
I wasn't really thinking of district judges who do, as you are implicitly accepting the bulk of the civil work in county courts. I was thinking of tribunal judges, a special tribunal. You're proposing a separate tribunal, a tribunal devoted to infected blood, in which case you might expect there to be judges who would be expert in that subject.
Well, sir, we wish to avoid what appears to have happened in the past, which is the scheme, the tribunal, getting into a certain way of thinking as to how compensation should be awarded. We believe that judges coming in fresh to the running the tribunal and then going back to their regular work will bring a breath of fresh air every time they're brought in. We don't want this to be seen simply as the same old, where it's the same judges dealing with it day after day. Other, of course.
So you want, as it were, a rotating panel of circuit judges?
Yes. So they can sit in this tribunal and then go back to their regular.
And how many weeks in a year would you expect them to be sitting?
Well, I won't condescend to the details of how often we should get judges to work.
The reason I ask is because to sit meaningfully, you might have to sit for a longish period, might you?
Yes. We were thinking somewhere in the order of 6 months. That will allow some training in the matters I've raised already about knowledge of the matter they're dealing with and the background to these claims, and it will enable them to get through this work.
Yes,
we believe. We're going to deal with High Court judges in a moment, so I wonder what comments you'll have about that, but we'll see when we come to them. In light of the behaviour of the trusts and schemes that previously controlled the systems for support, the hearings should be non-adversarial. Application should be allowed unless there is overwhelming evidence to the contrary. In respect of every decision, the tribunal must be given a judgment. All meetings should be fully minuted. All hearings should be conducted in private, but be fully recorded. All correspondence, documents, and minutes should be retained. The respondent, who will be allowed to have the same documents as that provided to the adjudicator, shall not be permitted to ask questions of the applicant. Many of those who've sought support in the past have been treated in a hostile, dismissive, or disbelieving manner. They should not be exposed to such behaviour again. The applicant may appeal on matters of principle and quantum to a higher level, where the adjudicator shall be a High Court judge. It's often said, sir, that there isn't much work for High Court judges, much civil work. Well, there will be now, at least for a few years.
Well, there's quite a lot of civil work, but it's not necessarily personal injury work.
No.
I think High Court judges, in my experience, have been pretty busy.
Well, you'd know more about that than I do, sir. If there aren't any High Court judges, then we could have senior circuit judges, of course.
Well, I think, yes. I shan't enter into a debate on the relative merits of senior circuit judges and High Court judges, for understandable reasons.
Well, so it's all about having status, the status of the judges who give
I understand the point.
So, there will be a positive obligation on all tribunals to complete an application within a reasonable time limit. There will be an annual audit assessing, amongst other things, the applications made, applications concluded, applications outstanding, amounts awarded. Until an application is fully resolved, compensation will be paid on the basis of the existing schemes. However, all applicants should receive the highest amount currently paid to any registrant and the existing 4 schemes. How should the scheme be run? When the scheme is established, all those presently registered on the 4 existing schemes will automatically be transferred to the new scheme. The scheme shall then be responsible for compensation and the ongoing regular financial support payments. All new registrants shall automatically be registered with a new scheme. All applicants shall have the right to file a statement setting out their history, why they are entitled to compensation, the extent to which they have or will suffer harm, and all past and future financial loss, together, if possible, with a schedule and list of sums of sort. In addition, they will be entitled to file such further lay evidence as they think fit. An IBI statement should be sufficient as long as it contains all or part of the relevant information sought. They can file reports from such experts as they think fit. The respondent can file just a brief reply. It will be a matter entirely for the applicant as to whether they give oral evidence, and no adverse inference can be drawn from their decision not to. It will be a matter entirely for the applicant as to whether they call oral evidence from any other lay witnesses or from their expert witnesses. We adopt Sir Robert's recommendation 4, but with some additions. So if we could just look at Sir Robert's report. These start at page 33, internal numbering. So if you just look very briefly at 1 and 2, they're matters I'm going to come back to, sir. I'd just like to deal with this as a primary matter. Recommendation 3 we'll come back to, but recommendation 4, over the page, he says this: I recommend that the scheme should, so far as possible, avoid legalistic and adversarial concepts of the burden and standard of proof. Establishing eligibility under the scheme should be either A, automatic in the case of infected persons already accepted on eligibility under the support schemes. We would add to that, and affected, So it would then read automatic in the case of infected or affected persons already accepted for eligibility under the support schemes. Or B, a collaborative process in respect of those not yet registered, in which, and then it sets out various things that the scheme should do to help the applicant.
The or there really means and, doesn't it?
Yes.
Because they're not alternatives, really.
No, they're not alternatives, sir. So we say that those who are registered now don't have to prove anything. They're automatically transferred. Things carry on as they are. They apply, as they no doubt would once they've considered their position, for compensation. Those who are not yet registered have to make an application. If we can leave out the Sir Robert's report. Eligibility. Those infected and affected with HBV should be awarded compensation on the same basis as those who are infected and affected by HCV and HIV, with the necessity to establish that it is a serious case of HBV. The reference to a serious case is found in recommendation 2. If we could go back a page. We say that, he says that he recommends that the scheme should offer redress to those infected with HCV and or HIV and defined serious cases of HBV. We invite you to say that the recommendation concerning defined serious cases of HBV be deleted, and there's simply a reference to HBV. I'm not going to go through all the reasons why HBV should be incorporated into this. It's been touched upon in some detail yesterday by Lloyd, and it may be touched upon this afternoon by Mr. Howells. Next, subject to amending subparagraph B by allowing claims for HBV as set out in recommendation 2, or we say should be in recommendation 2, by deleting subparagraph C, we adopt Sir Robert's recommendation 3. I'm sorry if that's a bit convoluted, sir, but that's the way we go around these matters. In light of the evidence received by the inquiry, including date of knowledge, self-sufficiency, and the caution that should have been exercised regarding the use of blood products, given its known potential for transferring viruses, the application of dates is unnecessary. So the starting position should be dates of exposure are irrelevant so long as there has been exposure and so long as they've developed one of the relevant conditions. If after the legal teams have met and the doctors have met, there's further consideration required about dates, then it can be given at that time, and the question of dates then become relevant. But the starting position is dates are not relevant. We recommend that those infected but self-cleared shall be entitled to register with a new scheme. Appropriate bans should be created to allow claims to be made for any harm suffered, in particular, any shock or distress experienced on being informed that they may have been exposed to contaminated blood. Save that the references to age at subparagraph B, C, and D be deleted, we adopt Sir Robert's recommendation 5. If we can just look at that. He recommended that the following relevant, indirectly affected persons should be admitted to the scheme. So we have spouses, etc. B, children of an eligible infected person. C, parents of an eligible infected person whose eligibility started in childhood. siblings living while under the age of 18 as a family with an eligible infected person. We say that those references to ages, either directly or implicitly, should be taken out. The matter people are going to be compensated for, if they are compensated, is something that struck not just individuals but families. It doesn't matter whether you were 18 at the time or whether your brother or sister were younger or older. Siblings would have suffered terrible hurt and shock and upset at what took place. The same will be in respect of parents. The same will obviously be in respect of children. This doesn't give a blanket of compensation to every single person, but it makes it available to those who've suffered harm without recourse to age limits. We endorse the proposal made by Sir Robert at page 132. You don't need to turn to it, Lawrence. That the approach of the scheme to the assessment of eligibility, starting with the demands made on applicants for information, should be to offer all the best chance possible of establishing entitlement, rather than to be searching energetically for reasons to exclude them. We then continue. Where there is an absence of medical records and the applicant asserts that they did receive blood products or blood transfusion, and/or medical expert states that the relevant medical procedure may have involved the use of blood or blood transfusion, there should be a presumption in favour of the applicant. The burden, and we say it should be a heavy burden, should be on the respondent to rebut that presumption. We now turn to the assessment of quantum of damages. So there are many different methods by which compensation could be calculated, but ultimately there seem to be two main methods, namely a system based on the common law calculations of damage. Sir Robert calls this a bespoke method, or two, a system based on set tariffs or bands of damages in respect of most types of loss. Sir Robert's report analyses the pros and cons of each method of compensation, and they'll be well known to you, sir, and has considered various types of compensation schemes in the UK and abroad. Sir Robert's report adopts a more nuanced approach, which is primarily tariff or band-based, but coupled with significant elements of common law principles, especially in respect to the calculation of future loss of earnings and future care. In addition, even in those areas where compensation is banded, Sir Robert seems to have allowed some wriggle room in respect of those who identify greater loss than might normally be expected. Some of our clients are attracted by the idea of a common law approach, individually assessed compensation, a bespoke method of calculation. It appears that there is a belief that because it is a bespoke approach, it is more likely to be accurate and therefore must be a more generous approach than that provided by the banded approach. Those experienced in the common law approach to compensation may think that these beliefs may be misconceived. To a greater or lesser extent, the amount awarded on a common law approach will be based on a considerable amount of guesswork, which in the long term probably renders it no more accurate or generous than a banded approach. The main problem, so far as this scheme is concerned, the main problem with a common law approach is the inevitable delay that occurs in the preparation of such a case, which is likely to differ considerably from every other case in nearly every respect. Applying some knowledge of personal injury claims and considering the experience of the Republic of Ireland, it seems to us to be inevitable that even a partial resolution of these claims for compensation will take a considerable time. That would be intolerable to the vast majority of the people that we represent and we suspect to everyone else. At recent conferences, many of our clients agreed that they wished the assessment of compensation to be carried out as fast and as quickly as possible. they much preferred a banded approach. Having been deprived of proper, appropriate, or any meaningful compensation, and indeed, in some cases, any compensation, for many decades, it would be unacceptable to introduce further delay. The following remarks, sir, are primarily directed to the assessment of compensations that advanced in Sir Robert's report, the banded approach. And if we can have the report of Sir Robert back up. And once again, it's internal numbering 35. So, Sir Robert's recommendation that infections eligible for compensation should be classified in the following manner. There should be defined categories for each type of eligible infection and the stages through which it progresses, and for each category defined degrees of severity to which a range of possible awards for the impact of the disease can be applied. The first one is that the stages and degrees of severity for each disease should be defined by an independent clinical expert advisory panel by reference to clinical professional consensus. We say that the infected and affected should also have representatives sat on that panel. It's intolerable that for the last 40 years they've been spoken about as exhibits or something to be considered at a distance. It's imperative that they have are able to provide some feedback into that committee. The same in respect of C. The range of potential awards for the impact should be determined by an independent legal expert advisory panel to be consistent with what would be awarded in common law personal injury litigation. There too, they should be represented. It's important that all participants, all claimants, feel confident that the various panels should have input from, if you like, their own side. And they're entitled to think of it as their own side, because the last 40 years it has been them and nearly everyone else. They've fought for the right to have this award of compensation. They should be represented. Subject to that, we adopt recommendation 6. We adopt recommendation 7. That deals with aggravated and exemplary damages, and it's a somewhat specialised area. We can leave that to one side. With the assistance of their lawyers, as we hope there are their lawyers, they can be taken to that to see if there is any merit in making such a claim. We adopt recommendation 8. That's the separate awards that are made to those eligible infected. I'm just going to read out the titles of the categories, but no more. So he recommends an injury impact award. He recommends a social impact award. He recommends a care award, an autonomy award, a financial loss award. Recommendation 8 is adopted. So far as recommendation 9, save for paragraph E, we also recommend paragraph 9. (9E) deals with a bereavement award. That has a fairly specialised meaning in common law claims. It's an award given to a limited number of people, and it's one award which is then, as you know, sir, spread out amongst various groups. In other words, if one starts with 15,000 people and there's 15 people who come into the various categories, unlikely to be 15, but one never knows, that's £1,000 each. It's often been thought that a claim under for bereavement under the Fatal Accidents Act, it's often been thought that the awards are derisory and often excludes those who most need help. Here, such an award would offer very little to those who suffered such grievous loss and would be grossly insulting. As we mentioned already, the outstanding feature of these claims for compensation is the way in which the diseases destroyed families. The effects of the diseases ran through families, and they still do. We contend that in respect of three categories, which we're going to identify, there should be a sum awarded to each claimant in those categories. So not 15,000 divided by 15, but 15,000, if that's the sum, and I'm not suggesting it should be for one moment, then 15,000 to each claimant. In fact, for obvious reasons, we say it should be considerably more than £15,000 to acknowledge the very great hurt loss of these people. So, we say this. We believe that a suitable sum should be awarded to mark the appalling loss suffered by parents, children and siblings. We recommend that each parent alive at the time of the child's death, regardless of the child's age, should be entitled to receive a fair and equitable amount. We recommend that each child should receive a similar amount in respect to the death of a parent, no matter what age the child was at the date of death. We recommend that each sibling should receive a similar amount irrespective of the age of the deceased or sibling at the time of death. And for the avoidance of doubt, these awards should be paid in addition to any other sum to be paid under any other head of loss. So we adopt recommendations 10, 11, 12, 13, and 15. I'm not going to read them out, otherwise we really will be here all day, but we adopt those recommendations as well. We also say that insurers, financial companies must provide financial products and mortgages to those infected and affected, and any difference in premium to those who would not be infected or affected should be underwritten by the government. We recommend that in its report the inquiry emphasises the need for appropriate compensation to be awarded in the following circumstances. We know that some of these categories are already dealt with by Sir Robert, but these are particular ones that concern our clients, and so we put them before you as standalone recommendations, if you will. So, first of all, where couples were warned that they should not have a child because of the risk that one or the other might be infected with one of the relevant diseases, as a result whereof they lost the opportunity of having children, there should be an award. Where couples were warned not to continue with a pregnancy because of the risk that one or other might be infected with one of the relevant diseases, and that as a result the pregnancy was terminated, there should be an award. Where couples are warned after their child was born of the risk that one or other might have been infected with one of the relevant diseases, then whether or not the child was infected, on second thought I should just alter that to even where the child was not infected, they should have an award for any shock and distress. A separate category, women carriers of haemophilia who in the late 1970s and early 1980s sought advice from clinicians as to the risk of having a child and were not warned of the risk of their child developing hepatitis and or HIV if they went ahead and had a child, and subsequently it transpired that there had been a significant risk, and we do know there was a significant risk, then even though the child was not infected, both parents and child could suffer significant shock, anxiety and upset, and if they did, they should be entitled to claim compensation. So to the extent we've not argued otherwise, we adopt recommendations 16 to 19. I just want to deal with some additional matters with future compensation. We've We say that once the inquiry has reported, it is likely there will be a flurry of activity until the new scheme is up and running. Following that, it is likely the public, press and government's interest in the blood scandal will diminish until it becomes, I'm afraid, sir, a distant memory. We contend that as well as an appropriate scheme of compensation, radical improvements in their healthcare and appropriate findings concerning wrongdoing, the infected and affected have the right to expect that the continued health and well-being of the infected and affected is supported, advanced and protected by some independent person or body to be established as soon as possible. These people who've suffered for so long should not be forgotten or cut adrift. We've invented the title of Infected Blood Victim Commissioner, but we're open to any more manageable title than that. So we say the infected and affected should play a part in setting up the scheme, and thereafter their views should be sought at regular intervals. The Commissioner should be fully funded, but wholly independent from the government, both UK and devolved. It is important that the Commissioner is established at the outset in order to play a constructive role in the establishing of the scheme. So, when we make this recommendation, we don't seek to replicate the established position of Victim Commissioner, which covers all manner of issues connected with the criminal law. Rather, we invite the inquiry to give consideration to the role of the Commissioner of Survivors of Institutional Childhood Abuse, an independent organisation established by the government to assist the victims and survivors following the report of the Historical Institutional Abuse Inquiry in Northern Ireland, which reported in 2017. The role of the Commissioner, presently we believe Fiona Ryan, is to empower victims and survivors to exercise their rights. The Commissioner has various statutory powers given to her, including powers to undertake or commission research, to compile information, to provide advice or information, to publish anything concerning their interests, and to make representations or recommendations to any person or body concerning the interests of victims and survivors. We recommend that a similar commissioner should be set up as soon as possible to represent the interests and to protect the well-being of the infected person. The Commissioner should be given a very wide discretion as to how they carry out their duties. Thus, the Commissioner should be allowed to campaign on behalf of the infected and affected, should be allowed to seek higher awards of compensation, and should be allowed to make recommendations to central or devolved governments regarding all matters affecting the lives and well-being of the infected and affected. So that's all we have to say about compensation. And I want to turn to the issue of healthcare.
Just a question, if I may, about compensation. The principle which Sir Robert sets out is that whatever scheme there may be, the monetary side of it will won't be out of step with what he calls common law damages. He recognises that he is an expert in the law of England and Wales. Now, you are here you're not representing Scotland, where the legal system is a little different, and the inquiry has taken advice on what the Scottish position on damages is. But can you help me with Northern Ireland at all? You may not be able to. If you can't, then please, by all means, add this later. But am I right or wrong in thinking that the guidelines for personal injury, the assessment of personal injury damages, which apply to England and Wales, may not apply with the same force in Northern Ireland?
Well, sir, I have some knowledge, and with Mr. Howells, and your experience is the same as ours. They're not the same as the damages awarded in Wales and England. The amounts suggested are not cast in stone, if you cast in stone, as they are here, and more interestingly to our clients is they tend to be more generous than they are in England and Wales. As far as that is concerned, that's as far as I can take it. We will, of course, if you wish, file further written submissions about the differences between Northern Ireland and Wales.
And the expression common law would apply to England, to Wales, and probably to Northern Ireland, but it wouldn't necessarily apply to Scotland, would it?
I don't know, sir. Tomorrow you have before you the...
Well, I could ask Mr. Dawson.
I think that's the best thing.
Yes.
I'd like, as I've said, I'd like to look at recommendations for healthcare. We have set out quite a lot of them. They go from page 93 of our written submissions, and they're set out in some considerable detail. I'm not going to go through all of them, but I just want to go through some of the major ones which will directly affect our clients. So, healthcare. The UK and devolved governments must establish multidisciplinary centres of excellence for the treatment of persons infected by blood and blood products. Such centres should provide access to all medical advice, including consultant haematology, consultant neurology. They can receive treatment, dentistry, and also specialist social work support that is commonly required by those who have been affected with HIV or hepatitis, with routine consideration being given to whether any referral should be prioritised. Further, the Department of Work and Pensions should undertake assessments for the purpose of applications for personal independence payments at such centres and provide be provided with bespoke training to the assessors who will be carrying out such assessments, drawing upon advice from the practitioners who operate from specialist centres. Second, a scheme of rapid transfer to multidisciplinary centres should be arranged from other outlying hospitals. It's been drawn to our attention that in Northern Ireland this is a particular problem. There is the main hospital, which under the scheme would be undoubtedly in Belfast. That makes it slightly skewed because it's far to the right and there are many people who live far to the left. And so SIM scheme has to be developed for rapid movement in serious cases or in those where it's thought it might develop into a serious case. The UK and devolved government should make available specialist mental health services to persons infected by blood and blood products and those affected by such infections at a trust or health board independent of the trust or health board who treated the infected person when they became infected. That's not mandatory, sir. It's a matter for the person who seeks treatment as to whether they wish to go to a new hospital or whether they are content to go to the hospital where they were treated. They must also establish a UK-wide system of counselling for those infected and affected by blood and blood products. The system should be accessible throughout the UK whenever and wherever the person may require it. The UK and devolved governments should design and implement a scheme which will confirm that a person has been infected by blood or blood products. This should be done in two ways. These are not alternatives, should be done in both. So first of all, a health card will be issued to every person infected by blood or blood products. Its appearance will be similar to that of a credit card. The production of this card will alert a healthcare employee that the holder of the card has been infected with infected blood. To maintain confidentiality, there will be nothing on it to indicate the purpose of this card. This card will be sufficient for a person to require priority treatment. Secondly, the UK and devolved governments should design and implement a health passport for persons infected by blood and blood products, so that upon presentation, a healthcare employee can see 1, a statement of the fact that the person was infected by blood or blood products, 2, the current status of the person's infection, presently infected, cleared or suppressed, etc. 3, the person's illnesses, symptoms and treatment side effects. 4, the person's treatment regime. 5, medicines that should not be prescribed. 6, if applicable, the severity of the person's haemophilia or whatever existing disease he has or she has and its complications. And 7, the necessary destination for ambulatory services. So paramedics will be provided with information and training in relation to the health passport. The health passport will require regular updating by the treating clinicians and should appear in a prominent way when the person's records are accessed digitally. It can also be provided in hard copy for the infected person. The digital passport should work across all the UK health departments so that a person, usually resident in one part of the UK, is not disadvantaged if they need to access healthcare provision in another part of the UK. The UK Health Department should adapt the criteria for organ transplants so that 1, persons infected by blood or blood products are able to receive a liver transplant after the age of 70. 2, prioritisation criteria which disproportionately affect persons infected by blood and blood products should be identified and disapplied in their cases. 3, the fact that a person was infected by blood or blood products should be a criterion which is adopted so that it leads to greater prioritisation, bearing in mind that liver failure develops more quickly in persons affected with hepatitis C than other causes, and they may have been affected for decades. The Medical Research Council should establish and fund research into the association between hepatitis C and brain disease, including but not limited to cognitive impairment, strokes and dementia. As an adjunct to this recommendation, clear guidance should be published by the Royal College of Pathologists on the decision to perform and conduct an autopsy of the brain for the purposes of such research. The UK Health Department should ensure that treatment for HIV is available at a place other than a GUM clinic for those who were infected through blood and blood products. The UK Health Department should ensure that persons infected with hepatitis C through blood or blood products is offered an appointment with a hepatologist and routine fibre scans every 6 to 12 months as appropriate. Blood transfusion practice. Where a clinician or health professional has administered or authorised a blood transfusion in contravention of the guidance contained within JPAC's transfusion handbook, there should be prima facie evidence for any GMC, NMC referral. The implementation of SHOT and SABTO's recommendations by NHS trusts and local health boards should be monitored by the health department, with a failure to comply being prima facie evidence of the trust or health board needing to go into special measures. The UK Health Department should fund the implementation of a standalone electronic system which provides the integration of GP and hospital systems, the integration of systems between health boards and trusts, allows data to be collected by the UK HSA, SABTO, JPAC and SHOT, and allows a single reporting portal for serious adverse events, serious adverse reactions, near misses, TTIs, and any other relevant information concerning transfusions. Medical schools should be required to cover haemovigilance as part of the curriculum. The JMC should be able to veto curricula developed by medical schools in order to provide recommendations for improvement. Where any healthcare practitioner administering a blood transfusion fails to 1, ensure the patient consents to the transfusion, and by that we mean proper, full and informed consent, fails to record the patient's consent, fails to record the transfusion is compatible with the patient, and record the justification for the transfusion, this should be prima facie evidence for GMC and or NMC referral. The UK Health Department should ensure that hospital transfusion committees, 1, complete annual audits to determine which blood products are being used, in what quantity and by which departments, 2, record the number of transfusion reactions, transfusion incompatibility incidents, bacterial infection, viral infections, and such other adverse reactions as a result of the provision of blood or blood products, however long after the transfusion they present, and report the same to SHOT. The UK Health Department should adopt into guidance the recommendations contained within SHOT and SAPTO's annual reports. That should be automatic, shouldn't require further legislation. So I think that's as far as I can take the recommendations in respect of future medical treatment. There are others, as you know, and but I'm not convinced that it would take the matter very much further this morning. So I see the time. We are a little early this time, but I'm just about to go on to past care, and I believe that might take me some time.
Yes, well, let us take a break now then, shall we? Would 10 to 2 suit you?
Any time would be suitable. I think everyone here, and I'm sure the listeners, would like to get on with this sooner rather than later, so I'm quite happy if we start again at half past 1.
Well, I think that may be a little early. People have to have their lunch and, if necessary, stretch their legs.
Yeah,
so
I see people nodding in agreement with you, so we'll go with the public.
So I think we'll stick with 10 to 2, shall we?
Very well, sir.